Welcome back to Sunrise Daily. Well, we'll continue our conversation on, as I say, it's a fight against corruption and the Ekiti State Governor and the EFCC and the law, the legality of EFCC's action, all of them in one basket, and that's what we're also focusing on again today. We're joined this morning by Mr. Emeka Ngige, Senior Advocate of Nigeria, who joins us from Abuja. Good morning and thank you for joining us today. Well, I know you know many citing Section 308, different sections of the Constitution, either supporting whichever views they also have to advance. But let's get your perspective on this. So tell us the legality or otherwise of EFCC's actions. Are they in the right to have done what they did, freezing the account of Ekiti State Governor?
Thank you, gentlemen, and good morning. I followed the debate, and in the print media, I have also made my intervention, and my stand, my own point of view, is that EFCC was in the right in the action it took. They have the power to freeze the account, if we use the word freeze, because that was the EFCC Act called it. And they have also the power to investigate, and the investigation is not limited to anybody, whether you have immunity or you don't have immunity, you can be investigated. I think everybody is in agreement that the Supreme Court has laid that point to rest in the case of Gani Fayose and the Inspector General of Police. So the issue now is the extent of investigation that EFCC can carry out, whether the freezing is part of investigation. And I think that it's very clear that when you are doing investigation, you have to suspend the operation of certain accounts when it comes to money laundering or unlawful looting of the treasury. So what the EFCC did in a summary is legal, is lawful, and can be defended.
Okay, but since in the course of investigating, if they are to freeze the account, the EFCC Act also says that they've got to obtain a court's order. You have to proceed to the court to get that order before you can freeze the account. And then in this case, the Section 308 also talked about the fact that you can't even take a sitting governor to court or prosecute or arrest or even invite him. So many just wonder that since you can't do that, predicating it on Section 308, how then or which courts will give you that injunction when they know that based on the principle of fair hearing, you can't hear him out and you unilaterally freeze their account. So they think that that's where there's a big question mark.
Well, I don't think those making that argument understand the angle EFCC is operating. The case is not between EFCC and Fayose per se. The case is between EFCC and Sambo Dasuki. That is the case where the former National Security Advisor superintended the disbursement of certain funds belonging to Nigerian people to certain individual or corporate accounts. And EFCC, in the course of investigation, in tracing where the money went, find that it has gone to certain accounts. It's not a case between them and Fayose. It is the case that started from investigation of the former National Security Advisor's role in arms procurement and what have you. So, strictly speaking, EFCC, by my own understanding, is not going to court to say EFCC versus Fayose. No. In applying for the order, they may apply under EFCC or Federal Republic of Nigeria versus Sambo Dasuki or versus Zenith Bank or versus any other person that is suspected to be involved in that transaction. So it's not right, by my own understanding, that they have a case in court upon which they got the freezing order against Fayose. I don't think so. So the order must have been against Zenith Bank.
So that means that the governor's account that is being frozen, he doesn't deserve what, fair hearing, because you're saying, well, since he's a third party, they can freeze his account without asking him any questions whatsoever. What if it turns out that he's innocent and then they wrongly froze his account? How will he have benefited from the principle of fair hearing?
Well, the law, the EFCC Act, specifically provided that the application for the freezing should be done ex parte. You can't tell an accused person to come and argue with you whether his account should be frozen. He will oppose it, and from there he will go to appeal up to Supreme Court. So it's not a question of denial of fair hearing. It is part of what the law provides for. Even in civil actions, you have ex parte order. There's one they call anti-impiller order. Those practicing intellectual property law, they know that area very well. Anti-impiller order, a court will grant you an order ex parte to enter into the premises of a person infringing on your trademark or copyright or design. You enter into that person's premises, you carry all the properties that are the subject of that infringement suit and bring it to court, where the court will now determine whether at the end of the case the properties will be destroyed or whether they should be returned to you. This is ex parte, anti-impiller order. And in the past, some challenges have been made that is unconstitutional. How can you get a court order and come to my house or to my shop and collect all the goods that I'm selling on the allegation that the goods infringe on your copyright or your trademark? And then I have not heard. And the court, House of Lords, and then in Nigeria, Supreme Court, they held that it did not violate the right of fair hearing. This is civil matter. So now that it's criminal, you suspect that certain amounts of money have moved out of the state treasury and is traced to a private individual's account. And then, because of fair hearing, you come and apply on notice for him to defend whether the order should be made. By the time the court finished the argument and there is objection upon objection, appeal to Court of Appeal to the Supreme Court, the rest will be lost. So I think that's why the makers of the law made it clear that you can do it ex parte. And I think it's right. It does not infringe on the constitutional right of the person. When the order is obtained, like in this Fayose's case, if in the end he is able to satisfy the authorities, maybe the Zenith Bank satisfy them that this money is not an illicit money, is not a laundered money, EFCC can return the money, or the EFCC can defreeze the account, and he will take his money. Yes.
As it is now, can the governor, who's got immunity going by what we have in Section 308, decide on his own to put on hold his immunity and say, let's truly investigate because I'm quite sure of what I'm saying? Can he do that?
Yes, he can do that. He can waive his immunity. It's allowed. He can waive it and decide to face EFCC frontally. He can do so.
And as it is now, we've been seeing back and forth, comments from Governor Fayose and Zenith Bank.